Dear learners, I welcome you all to this course on understanding human rights. Today we are going to discuss the status of minorities in India. We were discussing the major issues of violations of human rights in India, and in our previous lecture we discussed about the international obligations of India towards minorities. Then we also discussed Article 27 of the ICCPR that deals with the rights of minorities, especially with their identity, etc. Then we also discussed about the UN Declaration on Rights of Minorities. And then, in the light of those instruments of protection of minorities, we tried to find out what is there in India, what is the status of minorities in India. We also discussed about the definition of minorities, that is the most accepted definition of minorities that was developed by Francesco Capotorti. And then, what is the definition of in India? That also we have to understand the definition of minorities. So, before we go to the Constitution of India, first of all, we have to remember that for any kind of protection of minorities or promotion or protection of human rights, the interstate framework of international relations is important. So, the interstate framework of international relations and protection of minorities, what does it mean? It means that the supranational bodies or the international organizations like the United Nations or regional organizations, whatever we have in the world, they all have to operate in the interstate framework of international relations. It means that the treaties can be developed, well, adopted by the United Nations, instruments of human rights can be, or minority rights can be adopted by the United Nations, but ultimately the main responsibility of implementing the provisions of those treaties are there upon the states, member states. So that is why because the member states are the sovereign entities. So this is the reason that the sovereign independent states, they have been entrusted with the main responsibility to protect human rights or the rights of minorities and other vulnerable groups in their own respective territories. The United Nations and protections of minorities that we have to see. So India is rightly, the United Nations and protection of minorities. We have already discussed what is the international protection of minorities, and we discussed the instrument of protection of minorities under the United Nations. Now, India is rightly described as a confederation of minorities. When India is rightly described as a confederation of minorities, which highlights its multi-religious, multilingual, and multicultural character. When we say that it is a confederation of minorities, it is multi-religious, multilingual, and multicultural India. It means people from the diverse persuasion, people from different religions, people from the different cultures, people from people speaking many languages. They all live in India. In the Indian civilizational values, you will find Sarv Dharm Sambhava, that is respect to all religions, and Vasudeva Kutumbakam, that is oneness of mankind being rooted in its civilization, legitimizes the existence and rights of minorities in the country. So you'll find what have been the civilizational ethos of India, that is respect to all religions, equal respect to all religions, Sarva Dharma Sambhava. So it is basically the philosophy of mutual coexistence. And then Vasudeva Kutumbakam, it means all human beings, they belong to one human family. So that has been there right from the very beginning in our civilization, and that this is the reason that you will find people from different communities, caste, creed, sex, place of birth, etc. They all live in India, and that has been the beauty of India. That is unity in diversity. It is always emphasized. The Constitution of India ensures freedom of religion uh, to all its citizens under Article 25 to 28. So, all these citizens of India, they have been given the freedom of religion, that is freedom of conscience. We have already discussed in our discussion or in our lecture on fundamental rights and directive principle of state policy, what are the rights that have given to the citizens so far as the freedom of religion is concerned. So in the freedom of religion, when we discuss, we first of all find that it is the freedom of religion. It means the right to freedom of religion. That is a fundamental right. So under this, you see that the citizens have got the right to profess, practice, and propagate religion of their choice. So this is the right, which is a fundamental right. So the practices, and then of course every person has got the right to profess or practice and propagate religion of his or her choice. That is there. Again, you will find that there cannot be compulsory religious education in any institution which is receiving aid from the state, that or which is managed by the state. Also, all the people, every section of society has got, or all the every citizen has got the right to manage, or the religious domination, religious denominations. So the religious denominations, for example, you will find gurdwaras are managed by the Sikh community, for example, dargahs and other, you will find mosques, they are managed by the Muslim community of India. Similarly, you have thousands of Christian institutions in our country, the Christian denominations that are there in our country. Likewise, all the communities, they have their own denominations, and they will be managed by the respective communities. That right has been given. That is a fundamental right again. So we find that uh, although it is available to everyone, but minorities, especially because minorities all over the world, you will find the fear that the majority will try to impose its ideas, its values upon the minority, and this is a universal phenomenon that minorities, they want to preserve their identity. So here, and because of this freedom of religion which has been granted by the Constitution of India, the minorities have been assured that they have every right to preserve their religious identity or to preserve the symbols of their religion. Uh, this is the beauty of the Constitution of India. The Constitution of India recognizes minorities based on language and religion. Again, we should remember that so far as the Constitution of India is concerned, it recognizes two kinds of minorities: linguistic minorities and religious minorities. Article 29 and 30 deal with the fundamental rights of minorities. So, especially you see the fundamental rights of minorities when we are talking about it is Article 29, 30 especially. And this is the provision of the Constitution, that is cultural and educational rights is the heading of this particular article. So the cultural educational rights, and then you will find Article 29, and here it is protection of interest of minorities. So that is why cultural and educational rights, it has been mentioned. This is the title, but you will find that in the subheading you will find protection of interest of minorities. Any section of the citizens residing in the territory of India or any part thereof, having a distinct language, a script, or culture of its own, shall have the right to conserve the same. That is there. Any section of the citizens residing in the territory of India or any part thereof, having a distinct language, a script, or culture of its own, shall have the right to conserve the same. It means that minority, what kind of rights they have been, what kind of rights have been granted? First of all, minorities having any section of citizens residing in the territory of India or any part thereof, having a distinct language, that is linguistic identity, a script, again that is important, and then culture of its own, shall have the right to conserve the same. Then no citizen shall be denied admission into any educational institution maintained by the state or receiving aid out of state funds on grounds only of religion, race, caste, language, or any of them. So this non-discrimination principle is ensured, especially any institution which is receiving aid from the state or it is maintained by the state, to admission cannot be denied in those kind of institutions to anybody on ground only of religion, caste, creed, sex, place of birth, etc. So that is why here you will find that clause 1, article 29, clause 1 is very relevant for the minority from the point of view of preserving their cultural identity, preserving their script, or you see linguistic identity. And religious identity we have already discussed under 25 and 28. So 25 to 28, religious identity is being preserved and promoted. Article 29 is preserving article cultural identity and also the linguistic identity. And now you will find here that the principle of non-discrimination means on the ground only of religion, caste, creed, sex, place of birth, etc. Nobody can be denied admission in the educational institution which is being maintained by the state or receiving aid out of state funds. Now we are coming to Article 30, that is rights of minorities to establish and administer educational institutions. In the real sense, you will find this is the only right that has been conceded to minorities by the framers of the Constitution, or by it has been given to minorities by the Constitution of India. It is a specific right of minorities, a special right of minorities, and here you will find that Article 30, Clause 1 says, all minorities, whether based on religion or language. So, from Article 30, Clause 1, what is clear? That all minorities, whether based on religion or language. It means that the Constitution of India, for the purpose of Article 30, Clause 1, is recognizes two kinds of minority, that is linguistic minority and the religious minority. So all minorities, whether based on religion or language, shall have the right to establish and administer educational institutions of their choice. That is there. So when we say that all minorities based on a religion or language shall have the right to establish and administer educational institution of their choice, it means that these minorities, they want to preserve their identity. For example, there may be a linguistic minority which is living in a state where the language of the state, that is state in this sense is province, where the language of the state is different from the language of the that particular minority. Then that minority has every right to maintain its own educational institution, establish its own educational institution, so that it can preserve its language, culture, script, etc. So that is linguistic minority. Then again religious minority. Religious minority anywhere can have this right to establish and administer. So if a minority has established, then it has the right to administer as well. And when we say what is the meaning of administer, it means deciding the for example the recruitment policy, of course, and admission policy that will be determined by the minority that is maintaining that educational institution. So that will be there. But at the same time, we should remember that the judiciary in India, in many judgments on the issue of rights of minorities to establish and administer educational institution of their choice, has already ruled that right to administer doesn't mean right to maladminister. So it means the minorities, if they are managing their institution, so it doesn't mean that in the name of administration of the institution, since they have established, they will mismanage it, or they say, for example, they will determine the qualification which is not according to the merit, etc. So ultimately, because of this, you see the Supreme Court and the High Courts, they have ruled in many judgments that right to administer means that the administration must be efficient, and it should not compromise with the it should not compromise with the rules and the regulations that are framed by the government. Of course, the exceptions are there, but it should not compromise with the merit, the standard that is to be maintained in those institutions. So that is the best thing, and therefore right to administer doesn't mean right to maladminister. And exactly after Article 30 Clause 1, you have the Article 30 Clause 2, and that reads as, the state shall not, in granting aid to educational institutions, the state shall not, in granting aid to educational institutions, discriminate against any educational institution on the ground that it is under the management of a minority, whether based on religion or language. So it means when the state is going to give aid, so a state cannot discriminate against such institution on the ground that it is being managed or it has been established by the minorities or it is being managed by the minorities. You know, it means what is there, that if a minority has established an educational institution and it is administering, then a state is not going to discriminate, or a state shall not. It means a state must not discriminate against such institution while giving or grant or while giving aid. So here you will find, in a way, it becomes the fundamental right of the minority managed institutions to get aid from the state. So therefore, this cannot be ground, because most of the time I find that the people have a misunderstanding that if the government of India or the state government is providing aid to an institution which has been established and administered by the linguistic minority or religious minority, then it has to follow all the rules and regulations. There is no doubt in it. But you'll find the rules and regulations are there, but at the same time, the minorities have every right to maintain the distinct identity of that particular educational institution, and for that, whatever policies it is adopting, it is not in violation of Article 30 Clause 1 or Article 30 Clause 2 or Article 29 Clause 1. That is important. However, there are scholars or the experts of the Constitution who say that the last moment changes in the Constitutional Assembly, when the last moment changes were there in the drafting of this article, and when in the Article 29 especially, you'll find that minorities were replaced by any section of citizens, and that has created a dichotomy. And because of that, you will find in many cases, you see the contradiction is found between Article 29 and Article 30. If you see the intent, if you see the prenatal history, and if you see the subject heading and then the marginal heading, subheadings of this Article 29 and 30, you will find that the contradiction is there. And this is the reason that the last moment changes that were made and in this particular article, and what was proposed earlier was minorities that have been replaced with any section of citizens, which has created a lot of confusion. And this is the reason that there are experts on minority rights who say that the Article 30 Clause 1, Article 30 Clause 2, that must be liberated from the strangulating grip of Article 29, especially Article 29, 1, 2. So that is important in this from this point of view. Another important problem you will find that the term minorities has been used 4 times in the Constitution, but it did not define the term. Means the Constitution of India mentioned minorities. We already discussed the linguistic and religious minorities have been recognized by the Constitution of India, but you will find it was not defined what is a minority. Constitution of India did not define what is a minority. So it was left for the judiciary to define the term minority. The Supreme Court in the Kerala Education Bill took up the question of the discrimination of minorities in India. Determination of minorities in India means how to determine minorities. It ruled, in the Kerala Education Bill, and that is, of course, that definition has been accepted, or the point of determination has been accepted. So you'll find it ruled that a religious or linguistic group which is less than 50% of the state is a minority. A state here means province in our country, like Uttar Pradesh, like Bihar, like West Bengal, like Kerala. So, it ruled that the determination of minority, what should be there here? The distinct in the linguistic or the religious group, which is distinct from the majority and which has less than 50% of the total population of a particular state, is a minority. So the unit for the determination of minority will be a state, not at the national level the minorities will be determined. So say for example, there are many states in India which are Christian majority states. 2-3 states are there which are Christian majority states. There we will find where, for example, if the more than 50% Christians are there in a state, like say for example Nagaland or any other state, so then you will find there others, for example Hindus there, they will be minority. Earlier the Jammu and Kashmir, when it was a state, you will find that Kashmiri Pandits were recognized as minority. So this is the reason that what we have to understand in the light of the judgment that has been issued by the given by the Supreme Court of India, the criterion for determination of minority when we are going to consider, first of all, the state will be unit, and any segment of population which is less than 50% of that particular state will be considered as minority. So from here, this myth should not be there. The minority should be 2%, 5%. It is less than 50%. It means even if it is 49%, it will be termed as minority. This is the constitutional position. Then we should also see Article 15, Clause 5 and 6. B. Provide exceptions to educational institution established and administered under Article 30, Clause 1, so far as the application of special measures for the advancement of any socially and educationally backward classes of citizens or economically backward section is concerned. So it means that this kind of affirmative action program, for example, the reservation of scheduled caste, scheduled tribe, OBC, etc., it will not be applicable to minority educational institution. So the minority educational institution that is being, that are being run under Article 30, Clause 1, in those institutions, this kind of affirmative action program, for example, reservation program, that will not be applicable to these institutions. That we have to remember. In St. Stephen's College versus University of Delhi, 1992, the Supreme Court ruled that the minority community can admit the members of its community not exceeding 50% with preferential treatment in its established educational institutions. It means that if the minority educational institution is there, which has been established and being administered under Article 30, Clause 1 of the Indian Constitution, that institution has a right to give preferential treatment to its own community to maintain the minority character of that particular institution. But it should not exceed in any case more than 50% according to this particular judgment. So here you will find that the minority educational institutions have been given what is called the right to give preferential treatment to their own community for preserving the very minority character of that particular institution. So in the light of this, what we realize that the framers of the Indian Constitution, for example, because they could not ensure any other thing for the minorities, so therefore, so far as special rights are concerned, they have considered that these educational institutions in a way will be what we call a kind of autonomous cultural spaces for the minorities, so that they can preserve their culture, they can preserve their script. That is what the framers of the Constitution of India wanted. Besides constitutional protection of the rights of minorities, the Government of India created an institutional mechanism to protect the rights of religious minorities through the National Commission for Minorities Act 1992. So again we see that besides constitutional protection of the rights of minorities, the Government of India created an institutional mechanism to protect the rights of religious minorities through the National Commission for Minorities Act 1992. So what is there in that act? You see, the act established the National Commission for Minorities and identified 6 religious minorities: Muslims, Christians, Sikh, Buddhist, Parsis and Jains as the national minorities for the purpose of the act. So, there should not be any confusion at all. First of all, we see that the judiciary has already determined, and that too the Supreme Court of India has already determined, that for the determination of minorities, what will be the unit? A state will be the unit. Means province will be the unit. And I already mentioned that a state here means the provinces in India like West Bengal, Bihar, UP, Kerala, etc. So that will be the unit for the determination of minority for the purpose of Article 30. Okay? Article 29, 30 when we are discussing. Here, for the purpose of the National Commission for Minorities Act only, the Government of India has identified 6 national minorities. Yeah, that is for the purpose of National Commission for Minorities Act. So that is also there. Despite all the, this National Commission on Minorities is there to monitor the safeguards that have been provided to minorities, especially to preserve the rights of minorities, to promote the rights of minorities, to protect the rights of minorities, conduct studies, the functions, etc. We have already discussed in our previous lectures. So that is why you see not only constitutional framework, but there is also institutional mechanism for the protection of the rights of minorities. So institutional and constitutional or legal provisions for the protection of the interests of minorities we have already discussed. But despite all the safeguards, the institutional mechanism and constitutional provisions, the minorities in India have been facing many challenges. And some of these challenges are going to be identified here, but you will find that there are major issues of violations of rights of minorities that you will find most of the time discussed in the academia as well as in the newspapers and other means of communication. So, what are the major issues of violations of rights of minorities? First of all, it is violence against minorities and frequent communal riots. You see, the country was partitioned in 1947, and it was thought that the problem of communalism will be solved. But again, you see that the frequent communal riots or the recurrence of communal riots in India, they show in the post-independence communal riots I'm talking about, that partition cannot be a good solution to the communal problem. It is only the adjustment of the legitimate aspirations of different communities in a country can be the best solution for maintaining peace and harmony, etc. So you'll find the recurrence of communal riots. Most of the communal riots, for example, you see, are Hindu-Muslim riots in India. And Paul Brass, who has studied communal riots and he has written the production of Hindu-Muslim violence in India, and he says that these riots are not Hindu-Muslim riots, but most of the riots are basically anti-Muslim pogrom, according to him. So that is why you see, and if you see the casualties, and if you see the people who are killed in the police firing or in the during the communal riots, most of them are from minority community, although their population is less. So that is why it is always police is accused and other agencies are accused for violating the rights of minorities. And there are communal riots. For example, you will find the Jabalpur riots, Bombay riots 1992-93, Bhagalpur riots, then Meerut and Malyana riot 1987, 1984 anti-Sikh riot in Delhi alone, more than 3,000 Sikhs were killed. So you see that these riots, for example, in our country, the frequent communal riots, they are leading to displacement of minorities and flagrant violation of the rights of minorities. So that is one of the most important issues that are being highlighted by the minority scholars and others or the human rights organizations. So number two is social exclusion and marginalization. Minorities, here we should remember that all minorities are not in the same, they don't have same status. For example, the Jains or say for example the Parsis, they may be in a better position in comparison to other minorities. Even Christians can be better in a better position in comparison to the Neo-Buddhists and the Muslims, for example. They are the two most backward minorities in the country. And the backwardness, educational and economic backwardness, social exclusion and marginalization of Muslims especially, that have been highlighted by the Gopal Singh Committee report that was 1983. And then Sachar Committee report, that also came in 2006. You will find that they have highlighted the backwardness, social exclusion and marginalization of Muslims especially. Then inadequate political representation. The minorities in India, they constitute around 20% of Indian population, but you will find their representation in the political spaces is not adequate. And since there is no reservation of minorities in the political sphere, So ultimately, what happens that their representation is always falling short in the parliament and in the assemblies. So that is another important issue that the minorities are facing in this country, that the largest democracy of the world where the minorities are not getting adequate representation in the political spaces. Then social hostility. That what happens many a times the minority face the social hostility, means the society at large, means majority community, uh, it is alleged that they are hostile to the interest of minorities, their identity, etc., or their assertion of their identity, etc. So there may be many organizations, there may be some uh, people or the leaders or the organizations who want that the minority should be assimilated in the ethos of the majority, that is called assimilationist tendency. On the other hand, there are also people who say that the minorities don't try to integrate with the majority. So the integration is different and the assimilation is different. So that is why the national integration is something that should be the concern of everybody, whether majority or minority. But here, this allegation is also there, and the minorities, on the other hand, they blame that they face social hostility. Then complaints of discrimination and police atrocities. It has been also highlighted by the minority organizations or human rights organizations that minorities face brutality, atrocity during communal riots at the hands of police, and the role of police has not been impartial. This is one thing, that accusation is always there against the police or against paramilitary forces. That is also there, or in the encounters, for example, that the human rights organizations say they are mostly fake encounters where the minorities are killed in large number, and the third degree torture in the custody of the police. These issues are also, these allegations are also there. So, and then the last one is the issues of preservation and promotion of identity. Means that the identity of the minorities, means linguistic identity, their cultural identity, and their religious identity is something that is not welcome. And so that is why they say that a kind what is happening, that the minorities languages, the language that is spoken by the minority, and their own cultural symbols, they are not getting that kind of preservation and promotion in the country which is needed, or which has been emphasized in the UN Declaration on Rights of Minorities, or the Article 27 of ICCPR. That is also alleged. In conclusion, so we are going to quickly conclude. India has an international and constitution. India has international and constitutional obligations to promote and protect the rights of minorities. That we have already discussed. That we are party to many international conventions and treaties of human rights, or the rights of minorities, or the rights of vulnerable groups, and that is why it becomes India's international obligations, as well as you will find that there are constitutional provisions which are providing a special protection to minorities. So that is why it becomes the responsibility of India or Indian state or the government to protect and promote the rights of minorities. The second thing is, the definition of minorities in India is quite narrow and arithmetical. It does not consider the non-dominant position and the will to preserve identity to determine the minority. So you'll find that the definition that was offered by Capotorti, uh, so that is a quite inclusive kind of definition. Other things have been also taken into consideration, not only the in numerical inferiority. So there you will find it is numerical inferiority, non-dominant status, distinctiveness, and then the will to preserve that uh, distinction. So in India, what has happened because of this kind of determination of minority, we have two kinds of minorities: minorities by choice and minority by compulsion. So minority by choice, all the religious linguistic minorities, those who want to preserve their language and religious identity, they are minority by choice. But there are people, former untouchables, for example, that some kind of identity has been imposed upon them by the dominant section of the society. So they are minority by compulsion, not minority by choice, because they don't want to maintain that identity which have been imposed upon them for centuries. So that's why this is also problematic. Despite safeguards, minorities face many challenges in India. So we have already discussed what are the challenges, what are the issues that the minority organizations or the human rights organization allege that these are the major violations of rights of minorities. Lastly, India is a multi-religious, multilingual and multicultural country. Its diversity is its strength, which needs to be preserved and celebrated. So, thank you very much. With this, we are going to conclude this discussion on major issues of violations of human rights in India, especially the rights of minorities. Thank you.